Again, thank you all for attending. My name is Carl Mucciolo. I'm the moderator for this afternoon. I am a senior member of IFA. I also, a large portion of my business is tax appeals as well. Our two speakers today, we have the Honorable Joseph Andrusini, who has served as one of 12 New Jersey tax court judges since 2009. Prior to joining the bench, Judge Andrusini practiced law at Chasen, Lehner, Lamparello, the law offices of Dennis Ori and Andorra and Romano over a 23-year span of time. Additionally, he has served as general counsel for multiple municipal and government entities, including the Bergen County Improvement Authority, the City of Englewood Zoning Board of Adjustment, and the Borough of Fort Lee Zoning Board of Adjustment, the Borough of Fort Lee Planning Board, and he was assistant town attorney in West New York. Judge Andrusini received a Bachelor in Arts in Political Science from Fairleigh Dickinson University, a Master's in Education from Anatoch University, and a JD from Seton Hall University School of Law. Welcome, Judge Andrusini. Our second speaker, I'm sure you all know, is Chuck Blau, who is a counselor member Chuck's a counselor member of the National Association of Independent Fee Appraisers, and more importantly, as I'm sure you all know, he's our national president. Chuck's been involved in real estate valuation litigation in New Jersey since 1981. He has appeared before the United States Bankruptcy Court, the United States District Court, the New Jersey Tax Court, the New Jersey Superior Court, 14 county tax boards, and numerous condemnation commissions. In addition to being an attorney, Chuck is a real estate appraiser and has been elected president-elect of the National Association of Independent Fee Appraisers in Chicago, Illinois. Chuck is a graduate of Columbia High School in Maplewood, Emory University in Atlanta, Georgia, as well as a JD from Washington College of Law of America University in Washington, D.C. Chuck has lectured for the New Jersey Bar Association, the Essex County Bar Association, the New Jersey Institute of Continuing Legal Education, the Appraisal Institute, and the National Association of Independent Fee Appraisers. For many years, I asked Chuck, we've been friends for a number of years, why he would rather sit and be questioned as an appraiser rather than acting as an attorney and ask the questions. And I think he's finally realized that asking the questions is a lot easier than answering them. So please welcome Chuck.
Thank you.
I'm told that our speakers are going to run this very informally, so if you wish to ask a question during the session, just raise your hand. I'll try to run over to you with the mic so that we can record your question and everyone can hear it. So with that, Chuck?
Yep. Chuck, just before you start, there's just one disclaimer that I do have to give. The comments that I make today are my comments. They're not the comments of the judiciary of the state of New Jersey, nor the comments of the tax court of the state of New Jersey. And I reserve the right to change my opinion as we go forward.
As many of us do, we do reserve the right to change our opinion when we're in front of Judge Andrusini.
Very good.
Thank you.
Well, first, I want to welcome everyone here. I want to thank everyone from New Jersey who came to help fill the room. I want to welcome everyone from out of state for making the trip to our conference. I really appreciate it. I appreciate NAIFA giving me the opportunity to talk today. And I especially want to thank Bonnie, Diane, and Pam for help getting me ready last night. Something like that. I have a lot of slides, and one of the things that I learned last night is I have more slides than my allotted time, and I know most people are here to hear Judge Andrusini, so I'm going to go through some of the slides rather quickly so we have plenty of time for the judge and have questions and answers. I wrote this all up yesterday. The appraiser's role. Our role in tax appeals, and a lot of what I'm going to talk about is generic to any kind of expert testimony. It could be in bankruptcy court, it could be in all sorts of things. But our job as appraisers is to assist the trier of fact. You guys might be brilliant. If you're not able to assist the judge in understanding how you got to your opinion of market value, you've really failed as a witness. So just having a great appraisal alone isn't enough. You got to be able to explain it. You got to be able to be persuasive. It's one of my favorite things. You might have a great resume, you're honest, you're a nice guy. The judge should just believe anything you say. Problem is, the other guy's got a great resume too. And what this means is that your opinion as an expert doesn't do any better than the facts that you have. The more facts you have, then the less you have to put yourself out there, and it's sort of based on your opinion, and you have to answer or make adjustments where you don't have that complete support. Facts, usually, and facts are really the thing that can help win a case or not win a case. We don't always have great facts. You still have to come up with a well-documented appraisal anyway. Here's a write-up. One of the things that I see all the time when I'm reviewing an appraisal is sales write-ups, different things. And one of the things that you need to do in an appraisal is be consistent. Whatever you put in one write-up, you should have the same information in every single write-up. Now, in this write-up, one of the things that I notice is wrong is that it says the verifications with the deed. You can verify facts with the deed, the sales price, the grantor, and the grantee, but you can't verify if the sale is arm's length. If you can't convince the judge that it's an arm's length sale, and when I look at something like this, it makes me, as an attorney, wonder whether or not you have verified it's an arm's length sale. A lawyer will use basically the definition of market value as a roadmap to throw out that sale. So if you don't know it's between a willing buyer and a willing seller, if you don't know if there was duress, if you don't know it was well exposed to the market, you're going to lose that sale. So just putting deed is already giving me an inkling that you don't know the answers to any of those questions, because verification should have somebody's name.
Chuck, just a comment on that. Yesterday I had a trial, and an appraiser was testifying, and the attorney then moved to have the appraisal moved into evidence. And unfortunately, I didn't allow that, because the appraiser did just what Chuck is showing here. The only verification was deed and discussion with the assessor. That is not substantial information to tell me about that sale. I don't know if it's an arm's length. Was it a family transaction? Was there a divorce proceeding? Was it a bankruptcy proceeding? So if the appraiser didn't go out and investigate, talk to one of the principals, you're not going to get past that part. Your appraisal is going to fall.
So if the appraiser put in MLS with the MLS number and then turned around and said they interviewed the realtor who verified it was at arm's length and it was exposed on the open market, would that have sufficed?
The MLS part, no. But speaking with the broker, yes. Because the MLS may have information that's inaccurate. And the appraiser won't know that without speaking to a principal in that transaction.
If the tax assessment records show that it's a usable sale, doesn't that then make it a verified usable sale? Rather than a non-usable sale?
Well, we're going to have some slides, and we're going to get into some of that and some of these other questions. Because if we take all the questions now, we might not get to the next. We'll have another hour and a half of questions, and we won't get through this. And one other thing, I know we have some people from out of state. We've got some people from Chicago and stuff. We don't want to have a rowdy crowd, so just in case, between Carl, in case the judge needs this,
I can use it.
He can use this. So you guys got to be good. Here's another write-up, and some of these examples are going to answer some of those questions. This is a sale in Orange, New Jersey, from Robert Zimmerman to Richard Starkey. It has a date. It has a book and page. It says N.A. The book and page, this is a 2009 sale. The book and page is available. It is applicable. I'm not sure if it's N.A. for not available or not applicable, but all it tells me, if I'm going to cross-examine you, is you haven't talked to the attorney, you haven't looked at the deed. It's just showing me your weak spots really quickly. The other thing is you had a question about, the judge was talking about verifying something with the assessor. This says it was verified with the assessor. You might be able to verify that the assessor says it's 6,500 square feet and you looked at the property record card, but you can't verify that it's arm's length because he's not a party to the transaction. So again, this is a sale that you're making it really easy to get it thrown out. And it's just part of what we're supposed to do anyway, is to verify a sale is arm's length. That's really the most important thing that we need to find out. The third sale, What's different about this sale is that they added a line, they added land to building ratio for some reason. I see sales all the time where you see 3 or 4 sales, pages of sales, and they all have the same information, and one sale has something else, which immediately, if it's important, I already know that they don't know what that is for sale 1 and 2. The land to building ratio, at least you could figure it out on the witness stand. But if you tell me what the zoning is on one of them and you don't tell me the zoning on the other one, you probably don't know on the witness stand. It might not be important, but you're going to start getting embarrassed. And sometimes what an attorney does is take those little things that really aren't that important. By the end of the day, what's important, no one's going to believe you about what is important. The other thing is, it says it was verified, but in this case, when you have the same first name and last name of a grantor and grantee, James Madison to Dolly Madison, you might wonder maybe it is between related parties. Luckily, the appraiser verified it with the attorney, it should say Esquire, but it's Benedict Arnold, so maybe you can't believe him anyway. Just saying. So what does verify mean? Can you do it with the assessor? Well, some factual information, but not if it's arm's length. Can you do it with the deed? You can verify factual information, but not if it's arm's length. Can you verify it with the broker? Yeah, you can verify it with the broker. Buyer and seller? You can verify it with the buyer and seller. The deed abstract? No, only factual stuff. The attorney? Yes. Can you verify, this often happens with lease information, we get comp sales from another appraiser. Can you verify it with the appraiser who gave you the information? No, because he's not a party to the transaction, and we don't know what appraiser he got it from. I know in our office, in our database, when I get information from one of you guys, in case I might want to use it one day, I always put down where did I get the information so I can call up somebody and go, okay, did you verify it? Where did you get the information? So I can start to track down who I need to call, because I'm going to need to verify it myself.